Honorables sénatrices et sénateurs,
Honorable Senators,
by recognizing that we're gathering today on the traditional and unceded territories of the Algonquin and Anishinaabe people. We are grateful to live and work on these lands, and we must continue to reflect on how our laws, including citizenship laws, are shaped by our shared responsibilities. Colleagues, it's interesting that we are considering Bill C-3, an act to amend the Citizenship Act related to the restoration and acquisition of Canadian citizenship, at the same time as the Senate is considering Bill S-2, an act to amend the Indian Act, new registration entitlements. While today we are concerned about restoring the rights and entitlements to Canadian citizenship by descent, our colleagues in the Indigenous Peoples Committee have been studying a law which addresses some of the remaining inequities in the registration and band membership provisions of the Indian Act. Both of these laws are about the right to belong, about identity. As a Nova Scotian who has spent much of my career working with communities in Canada and around the world, I've seen how belonging, identity, and citizenship shape people's lives. I've heard from families who carry Canada in their hearts, whether they live in Antigonish, Edmonton, Botswana, or Bolivia. Their experiences remind us that citizenship is about more than paperwork. It's about connection. It's both a privilege and a profound bond. And for many of those we are talking about today, it's actually a right. By way of background, on January 1st, 1947, cast your minds back to 1947, the Canadian Citizenship Act came into force. That marked the beginning of Canadian citizenship as a legal status. Prior to this post-Second World War initiative of the government of Prime Minister William Lyon Mackenzie King, individuals born in Canada and naturalized immigrants were classified as British subjects. The Canadian Citizenship Act was a significant expression of Canada's emerging sense of national identity. The government also hoped that the creation of Canadian citizenship would alleviate racial and ethnic tensions in Canada and foster a sense of unity amongst its increasingly diverse population. In Canada's first citizenship ceremony, on January 3rd, 1947, 26 individuals were presented with their certificates of Canadian citizenship. Among the recipients was Prime Minister Mackenzie King himself. He received certificate number 0001. The Canadian Citizenship Act established 3 ways to acquire Canadian citizenship. 1, by birth on soil, if a person was born in Canada. 2, by naturalization, if a person immigrated to Canada and acquired Canadian citizenship status. And 3, by descent. If a person was born outside of Canada, they could derive citizenship from a Canadian citizen parent. A new Citizenship Act was introduced in 1977, which maintained those 3 ways to acquire Canadian citizenship. And it did remedy some of the obstacles to citizenship which had resulted in lost Canadians earlier on, but it did not resolve all. Today we're discussing a bill that many have been waiting for, one that aims to address long-standing issues in Canada's Citizenship Act, so it better reflects both the value of Canadian citizenship and the reality of how Canadian families live today in our very, very interconnected world. Over the years, changes to our citizenship laws have had some unacceptable consequences for Canadian families. In particular, the first-generation limit, introduced in 2009. It has meant that a Canadian citizen born outside of our country who acquired citizenship by descent generally cannot pass that citizenship to their child if that child is also born abroad. This includes families with genuine ties to Canada. This included families like mine, and I suspect families of some of my Senate colleagues. I know Senator Beam, for example, had 2 children born outside of Canada. Just imagine all the children born to Canadian Armed Forces personnel while the families were posted in Europe, to Canadian diplomats posted around the world, to Canadians working for the UN or international NGOs, or Canadians running or working for international businesses. Now, a personal story. On April 8th, 1982, I'm going to take you with me into my labor. By the light of a kerosene lantern, assisted by 2 highly skilled Botswana midwives in the Seventh-day Adventist Hospital in Kanye, Botswana, I gave birth to my youngest daughter, Lindelwa Naledi. My husband and I had been living in Botswana for close to 2.5 years. I was working for the Ministry of Commerce and Industry as the Rural Industrial Officer for the Southern District of that country. Our 6-year-old daughter, Emily, and our almost 3-year-old daughter, Lauren, were born in Canada. At 27 years old, I had no idea that the rights of my new baby, born that night, would be different from those of her Canadian-born sisters. Lindy did get her Canadian citizenship as the daughter of 2 Canadians. But when she gave birth in 2017 and 2019 to her 2 daughters in Monterrey, Mexico, she did not have the right to pass on her Canadian citizenship to her children, Violetta and Sierra, my 2 youngest grandchildren. Those children did get their Canadian citizenship through their Nova Scotia-born father, not through their mother, my daughter. If her partner had been Mexican or any other nationality, they would not have had the right to Canadian citizenship, even though their mom was Canadian, and her mom is a Canadian senator. Her sisters, Emily and Lauren, could have passed on their citizenship to their children, no matter where those children were born in the world, because these first 2 children of mine were born in Canada. This didn't end up being tested for them because my other grandchildren were born in Edmonton, Halifax, and Antigonish. So colleagues, look at this. You have 3 sisters, my 3 daughters, all Canadian, all born to Canadian parents, who before Bill C-3 do not have the same right to pass on their citizenship. Fortunately, in the Bjorkquist litigation in 2023, the Ontario Superior Court of Justice declared that key provisions of the first-generation limit on citizenship by descent are unconstitutional. The court found that this limit, as it stands, is inconsistent with the Charter. The court has suspended this declaration from coming into effect until November 20th, a date that's coming up very soon. Unless we act by that date, the court's declaration will come into force and citizenship by descent will have no limit for many, while some lost Canadians will remain in limbo. That's why I urge this chamber to move this legislation forward as quickly as possible. The term lost Canadians has generally been used to describe those who lost or never acquired citizenship due to certain outdated provisions of former citizenship legislation. Bill C-3 is a reasonable response to the court's declaration. It affirms that the right to citizenship, as confirmed under this bill, can't come with arbitrary restrictions, and it strikes an important balance, ensuring fair access while protecting the value of Canadian citizenship. Let me outline several features that speak to the clarity and fairness of this bill. First, Bill C-3 proposes clear rules for access to citizenship by descent going forward from this point on. In future cases where the Canadian parent was born or adopted abroad, their child, born or adopted abroad, can access citizenship as long as the parent has a substantial connection to Canada. Substantial connection is shown by being physically present in Canada for 1,095 days or 3 years cumulatively before the child's birth or adoption. The government chose this approach because it's similar to the 1,095-day physical presence requirement for naturalization. It recognizes that Canadians born abroad may have established a connection to Canada and that this connection can continue to be maintained while pursuing opportunities abroad, as many Canadians do. For example, a Canadian born abroad may spend most of their childhood in Canada, choose to come study here, or accumulate time in our country through visiting and/or caring for family members. Second, the legislation addresses historical gaps, like the one I was just talking about. If enacted, this bill would confer citizenship on those subject to that first-generation limit, meaning all those born abroad in second or subsequent generations to a Canadian parent before this legislation comes into force. This would have been the case for my Mexican-born grandkids of my Botswana-born daughter if they hadn't had a Canadian-born dad. This will be the case for friends of mine who live in Washington, D.C., and probably friends of many of yours. My friend Annie is a Canadian by descent through her mom. Her 2 children were born in the U.S., as was she. Her children are not currently automatically eligible to Canadian citizenship due to the first-generation cutoff. With Bill C-3 coming into force, her children will receive their Canadian citizenship. This bill will also restore the citizenship of people who previously lost it due to the now repealed age 28 requirement. This was a situation whereby some Canadian citizens born abroad lost their citizenship if they did not apply to retain it by age 28, as was required at that time by Section 8 of the Citizenship Act. This includes people who considered themselves Canadian in every way or lost citizenship unknowingly. Bill C-3 ensures the law will finally reflect that reality. Third, the bill maintains the framework that provides similar access, and this is very important, to citizenship for families who adopt children abroad. This will ensure that before the bill becomes law, families have access to citizenship through the direct grant pathway, the other pathway is a naturalization pathway, for all children adopted by a Canadian parent. They will have access after it becomes law, provided the Canadian parent who was also born or adopted abroad has accumulated the required 3 years of physical presence in Canada. This will align the approach for both children born abroad and adopted abroad. So fourth, Bill C-3 provides for access to a simplified process for those who may automatically receive Canadian citizenship through these changes, but they don't wish to keep it. For example, in some cases where dual citizenship may conflict with another country's laws. We've heard concerns that Bill C-3 could mean hundreds of thousands of new citizenship, which could put pressure on social services. No one can actually give a precise forecast of how many people will become citizens through Bill C-3 because Canada has not tracked births abroad since 1977. Uptake also depends on future personal choices, where Canadians have children, whether they even do so or how many they might have, and whether any of these new citizens would choose to come forward to seek proof of their new citizenship. What we do know is that between January 2024 and July 2025, IRCC received just over 4,200 applications for discretionary grants of citizenship under the interim measure for those affected by this first-generation limit. Since the government introduced previous amendments in 2009 and 2015, in that period, around 20,000 lost Canadians have come forward to apply for proof of their citizenship. IRCC received fewer than 2,400 applications per year from lost Canadians in the busiest years after the changes during that period came into effect. Based on that evidence, today, IRCC anticipates volumes in the tens of thousands over time, not hundreds of thousands. When it comes to the question of the cost to Canada, it's true that anyone who becomes a citizen as a result of Bill C-3 will be entitled, like any other citizen, to access the government programs or services for which they are eligible. That's the key, for which they are eligible. It's important to note that for every program or service, whether federal or provincial, each one of them has its own eligibility criteria. These criteria could include age, income level, tax filing, or residence in Canada, or residence in a specific province or territory for a specific amount of time, and they don't just depend on whether or not a person is a citizen. Anyone who applies to any specific program would need to meet all the relevant criteria to benefit from the program or service, just like any other Canadian would. We've also heard suggestions that the legislation should impose security checks on people who become citizens under Bill C-3. A cohort, I should note, is largely low-risk children, or that these people should pass a test verifying their proficiency in one of Canada's official languages. Citizenship by descent has never required screening for security, criminality, or language proficiency, and Bill C-3, consistent with the amendments the government made to citizenship by descent in 2009 and 2015, keeps it that way. Bill C-3 is about citizenship. It is not an immigration law. As senators, we have a duty to ensure our citizenship laws are fair, inclusive, and reflective of how Canadian families live today, here at home and around the world. This chamber has often come together to address complex, long-standing issues with care and pragmatism. Bill C-3 is precisely such an issue. I also want to acknowledge the groundwork that has brought us to this moment. Parliament has taken steps over time to restore citizenship to those affected by the first-generation limit, including thoughtful deliberations around Bill S-245 and the former Bill C-71, the valuable contributions made at committee. This bill builds on that work with a complete and forward-looking solution, one that restores what was lost and provides access to citizenship to those who have a genuine connection to Canada. With Bill C-3, we could provide a framework that's consistent with the long-standing treatment of citizenship by descent, avoids unnecessary barriers, and addresses legitimate concerns with evidence rather than conjecture. In my work around the world, I've witnessed the difference that clear, fair, and compassionate laws can make. With this bill, we have the opportunity to ensure our citizenship framework does not arbitrarily divide Canadian families, and that it recognizes genuine ties to Canada in a way that is principled and, quite frankly, practical. Colleagues, the deadline facing us is real, and we have a responsibility as parliamentarians to right some historical wrongs. Colleagues, the lost Canadians who will be brought home through Bill C-3 were not lost through any actions of their own or of their parents. I urge you to adopt Bill C-3 so that it can be referred to committee without delay. Thank you. Merci. Walalio.